MFA 3681 of 2019 is allowed in part. The market value of the land measuring 17 guntas in survey number so and so is redetermined at rupees 200 rupees per square feet. MFA crop 63 of 2020 is allowed in part. The claimant is entitled additional compensation rupees 4,59,459 with all benefits as per the law.
Yes.
Maloj, matter for the end of the list, a new matter, Maloj, education matter. There's an urgency. But Maloj have a lot of matters today. Could it be taken up tomorrow with kind permission to Maloj serve advance copy on the standing council KEM?
Please do.
Correct. Page wise, page wise.
Please. Number code. Any mentioning? List 1, page 1, seal number 1 to 3. Seal number page 2, seal number 4 to 6.
2 Your Honor. Kindly short it. Arguing counsel is not.
Time barred reference. You are for the
I am for plenty.
SLA.
SLA. Kindly 1 week. Date here.
2020.
Yes, madam.
Speed.
Arguing counsel is changed. That's why I am asking on short accommodation.
Learned counsel for the appearance. It's a short
Ah,
accommodation. List after a week.
Can you fix on date here?
I represent
6 to.
one lady. Last time also they have taken the time.
Last chance. We'll give a date.
Yes.
Please give a date. 6 to.
Much obliged. Much obliged. Much obliged.
Serial number 6. You to take an off next week, serial number 6. How to take the steps.
6, 45A. Stamp Act. Undervaluation. Covered matter.
Next week. isn't it?
Shahnaz, Bilal and others is the second one. That is the reported judgment.
Yes, ma'am.
There are so many parties there.
2 weeks.
Every lawyer appears to be
Hmm.
appearing in this case. With regard to the weeks.
2 weeks meantime.
Who appears for the respondents?
Sir,
Vaishali Hegde.
I will inform.
Shall we just deal with it when we come to it? It's only item number 6 because there are so many parties, which is why we thought. Yes, convenient date we can fix and list it.
Page 11, number 7 to 10. Page 12, 11 to 13.
Well, I have taken steps. Let the last thing done.
needful is
Well,
stated to
yes.
have been done. Register, verify and process.
Great.
Proceed.
Page 13, number 14 and 15.
Now 15. Take have next week. Steps I have to take.
We need to dictate that.
Tell
We
her.
can wait here, no, for some
Yeah,
time.
I will. Sure.
In orders, don't make mention. It's
Sorry.
not correct. We have to
Sorry.
dictate. Everybody will be waiting. Wait
Sorry.
for a few minutes.
Sorry.
You will be here only, no?
Page 14, 18, 16 and 17. Page 15, 18 and 19. Page 16, 20 to 23.
Lord, serial number 23, my lord. I
Yes.
appear for appellant. My lord,
Yes.
it's a joint submission. The matter may be referred to Lok Adalat. I've spoken to Mr. Shekhar, my lord. He is agreeable, my lord.
It is, cannot be 23.
22.
My lord, 22, my
is-
lord. It's 22, my lord.
22.
22. my lord.
At the joint request, matter is referred to the Lok Adalat.
There is a filing delay. Anyway,
Obliged.
Delay will condone, Barkonbudi first. Accepting the cost shown, delay of 185 days in preparing the appeal is condoned.
yes,
Obliged.
Accordingly, IS one is allowed.
Page 17, 24 and 25. Page 18, 26 and 27. Page 19, 28 to 31.
you've informed the other side. 2013 RFA.
At the request of learned
My
counsel
lord.
for the appellant. List on
Is it-
swans.
Serial number 20, my lord. My lord, serial number 20, my lord. I had to serve the notice to counsel, my lord, representing petitioner. I will serve it on the next hearing date, my lord.
Please wait, please wait.
20.
Yes,
Page 20, seal number 32 and 33.
Lordship, serial number 32, final hearing, my lordship. Kindly, 2 weeks time, my lord. 32 and 32.1, my lord.
amended cost title,
32.
Yes,
2,
32, my lord.
sorry, sir.
Why would
Yes.
we take up all these? small
2018.
Yes, my lord.
LAC.
I have it, my lordship, 2 weeks, my lord. When my personal
Ah.
convenience.
matters? I request to learn counsel for the appellant list after
17
2 weeks. Records ಬಂದಿದ್ಯಾ ma'am?
Page 21, seal number 34. Page 22, 35 to 38. Page,
My lord, serial number 37. Lords may have it next week. A date may be fixed.
For the respondent, my lord. The
Can we-
date may fix, yes.
The request of the learned counsel for the appellant list, please give a date.
7 to
Grateful.
page 23, seal number 39. List 2. Order, seal number 1, Avinashvi.
Item number 1, custody of a minor child.
My lord, in list
7
number
years.
one, my lord, in list number one,
List number 2. List number 2 is the habeas corpus matters council.
Clear custody.
Clear custody.
Notice is order, steps are to take.
Custody with the mother is said to be illegal custody. And no family court matter.
Family court matters there.
There is
It's pending
family
since 2019. MC 5066 of 2019.
Only MC.
Custody it is pending.
Oh, for custody it's
Custody
there.
also.
Pass out, pass out.
ಎಲ್ಲಿದೆ? ಯಾವ್ರು ಹೇಳ್ಬೇಕು?
Password.
Yes,
Seal number 2, Rakshita.
This is the case where,
Wife, we see, virtually see one.
yes,
she is before the court.
present.
Is there? Become, Madam Court Officer, correct. Or
She has just turned 18, so therefore.
what's your name? You understand English?
You can
English ಅರ್ಥ ಆಗತ್ತೆ? ಅರ್ಥ ಆಗತ್ತೆ? ಅರ್ಥ ಆಗತ್ತೆ? What is your name? Kirtana. Where you went? Where you went? You are with your parents.
Your own free will, no problem.
What is your age now? Date of birth? 1? 2006. What you have studied? First year. List on so and so, finally.
Call for
Records are-
records.
ಬಂದಿದೆಯಲ್ಲ records? ಬಂದಿದೆ.
Record ಬರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ
Call for records.
record there is already an order for calling for records.
ಇಲ್ಲ ಸರ್ ನೋಡಿದ್ರು.
ಇಲ್ಲ in a connected matter.
You shall secure the record telephonically and verbally.
Yes, 12:50.
My lord, in
Same.
connected matters, I have filed a amended cost title also, separate cost title also filed.
Council, it's connected matter.
Connected matter, I already filed connect.
Amended cost title is filed, same is taken on record. Yes.
Yes,
Paper
Date may
book
be
will
fixed
kindly be
for
dispensed.
hearing or calling for the
Paper
record.
book can be dispensed with because record, if once record comes,
Yes, yes. We are not saying anything on that. Paper
yes,
book,
we have not called, asked for paper book.
list of
Yes.
2 weeks ago.
18 to
please.
2 urgent, seal number 3, Manuke,
Leo. 15,56,000 to 54 lakhs.
15 lakhs has gone to 54 lakhs. 50% is directed to be deposited with all benefits. They want to withdraw it not without any conditions. There are, of course, in all fairness, I must point out, there are 3 kinds of orders which have been passed. One with security. One lot appears to be on some concession, but we'll be moving an application to modify that, which says not that it can be withdrawn 50%. And the third is subject to the result of the appeal. So there are 3 orders which have been passed in a batch of petitions. There are about 32 matters. In 32 matters, there are 17 applications for withdrawal. In that, by mistake, there seems to be 3 orders which have been passed, which appears to be concessions by counsel saying it can be withdrawn. But in others, there's an order directing security to be provided, or at least not an indemnity, because the increase is 4-fold.
That is the condition imposed. I have produced that also, madam. Page 24, district court released the amount to others, getting the indemnity upon, that already is there. District court. Page 34, already direction is there.
Indemnity is one form they will take and send. Indemnity is undertaking. They will.
At least some security should be offered
Indemnity
because
bond,
of the increase. The reason, my lord, why I'm saying this is, it's 4 times.
We'll record that, say that indemnity they should furnish before the trial court.
And maybe some other surety, my lord, can be provided by someone else.
Sir, he has lost everything. What?
No, land loser who's, my lord, of course, he has to get the fair compensation.
Amount according to you, at least to that extent. You should not have
According
any
to us, my
abuse.
lord, it couldn't exceed more than 20 lakhs.
More than 25 matters, some of the cases your housing board said no objection.
Yes.
Yes. So
In 3 cases.
some of the cases.
That's
at
the
least-
mistake which we are correcting, my lord, because we have to move an application to correct it. Because it can't be, what apparently happened,
Just
my
how
lord,
much you don't have any objection without
15
any condition.
15 lakhs.
About
For 20 lakhs, not there is no objection.
14 matter already before district court.
Hello, we've remitted the money.
No, this is, we should not be wasting our time on all these things. You take admitted amount, around 25 lakh is all right.
20 lakhs. in total.
50%, whatever it, they deposit laid off, my lord.
So
Yeah,
we
may I
can make
receive
a call if you are ready to.
May I
furnish-
make a submission, my lord?
20 lakhs per acre, my lord, can be withdrawn.
Nada. This is 2012 notification. Nada. The national highways are also acquired some portions. They have received 54 lakhs of other lands, acquired the same
is-
notification.
Further away from these lands, not even close by. And the guideline value, my lord, as rectified, was about 11 lakhs. We paid the determination by land acquisition officer was 15 lakhs. It has been enhanced 4 times to 60 lakhs.
They will give
24 matters
indemnity,
are released, my lord.
50%. 50% they will give indemnity,
50%
Yes,
to about
madam.
30 lakhs.
whatever. Third matter, Sri Kanchana Parliament Council appearing for the appellant. PV Chandrasekhar Council for the applicant orders on IA number 3 of 24. Present application is filed seeking modification of the order dated 30th April 2024. The said order reads as under. Third, Sri Kanchana Parliament appearing for the appellant submits that the reference court has exorbitantly enhanced the compensation, which is 4 times the market value, actual market value. And if the response are permitted to withdraw the said amount, and if they succeed in the appeal, it would be difficult for them to recover the same. Stop per contra, Sri PV Chandrasekhar and counsel appearing for the claimant, applicant submits that they are ready to furnish indemnity for the amount, and in support of his submission, he placed a memo along with the copies of the orders passed by this court in other appeals, and submits that in those appeals, this court has permitted the claimants to withdraw the 50% of the amount which is in deposit before the reference court. Hence, he seeks to modify the order dated so and so by allowing the applicant claimant to withdraw the 50% amount in his deposit. We have heard the arguments of on both sides, considered the material available in record. The matter requires detailed consideration. The respondent claimant volunteers that he would execute the indemnity bond. Keeping the said submission in mind, we are of the considered view that the order dated 30th/8/2024 is required to be modified. Full stop. Accordingly, the claimants are permitted to, applicant claimants are permitted to withdraw the 50% amount in deposit before the reference court. Reference court, Allah?
District court
District
in,
court. District court.
yes, madam. Because under the new act, authority, district court, authority,
Subject to applicant claimant
executing
furnishing-
indemnity. bond.
putting the
Indemnity.
indemnity bond before the said court.
Same format.
And the
Yes,
first
fine.
matter, it is not admitted, I think, madam.
One and
Other, all of the matters are admitted.
same, one common order ಮಾಡಿದ್ರೆ ಸಾಕಲ್ಲ, one common order is
Yes,
sufficient.
Lower court records, maybe, all from.
All for TCR.
First matter is
Just along with the connected.
not
cases.
admitted, lordship may formal admit, madam.
Admit, call for
I
TCR.
have only one request, but these matters can be taken up
Yes.
because of, if your lordships can fix some date.
My friend, file paperwork in one case, madam, we can.
Yes, yes, it's
finish
because there's no evidence except the acquisition notification in NHI and the distance here. If that is examined, it will become apparent as to what the situation is.
List along with the connected matters on give a date.
Very good.
Connected cases number 2. ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ಅದು ಆಯ್ತು. Preliminary hearing, seal number 4, mortgage fee charity.
HSR layout, notification of 15/12/84.
Yes, ma'am. Award is,
Does no award, no possession, held lapse.
award is passed, possession is taken, everything is done. I have filed the application for additional documents. And my lord,
Seek review.
he had filed,
You did not produce any of this before the learned civil judge.
I
You
have-
did not seek a review then.
I have filed, my lordship may take those documents. He had filed a writ earlier.
Was this before the learned civil judge is the question?
No, no,
Should it not go before the learned civil judge for a consideration then?
Seems it, no, I think.
yes. Lord, it has to
You-
be, Lord, in principle, it has to be. The fact that he had earlier filed a writ petition seeking for regularization of his 30/40 site. But that goes contrary to his pleadings. What your lordships are exercising the same power as that of the learned single judge under 226. But it's not virtually an appeal court. Lordships, it's in continuation of the proceedings. Lordship may take note of those documents. Lord, instead of relegating us back to the learned single judge. Lord,
Why
both of us will lose a,
all your negligence, no? Why you are not brought all these?
Lord,
At any stage, you can't come and say, no?
I
There
understand
must
that,
be some finality.
but I
There
understand.
will not be end for the litigation. You would have come and
Yes,
said
but
before
the-
single.
So the
judge,
fact
or
that
avail that remedy of review. Limitation, all these things are there, that is the reason.
what had happened, a word was passed, the petitioner himself says that the award should be, I write a letter to the Tashildar asking as to whom I should pay, because this seems to be a Kharab, no, sorry, not this. But here, he had earlier filed, but I had a writ petition also. Lakshmi, take it on Tuesday, my lord, by then my application will also be on record. I have already filed an application.
For what? Production of
And
additional-
production of additional documents to bring it to your lordship's notice.
Single judge says that acquisition proceeding in respect of the adjacent lands have been withdrawn, denotified, as can be seen from orders at annexure E to E3. Further, despite earlier orders of this court in WP number so-and-so and WP2 WPs, directing to consider the representation of the petitioner to drop the subject land from acquisition, PDA had not taken any steps, action in this regard, as such petitioner.
Already road was.
File your objections in the writ petition.
And then
Objections are. That's why I,
you can't do no.
Lakshmi.
What could the?
Road is
legislative
already
agenda-
formed. Road is already formed and this extent, public are using.
Oh.
Not,
Where is the material for that?
I'll place that.
I will not be waiting for all this.
It can be.
Lakshmi,
You can't develop islands, no. Adjacent
but
land
the-
is already deleted.
not an island, but the road for the public facility. If now tomorrow, if it is held that,
2014 writ petition
yes,
decided on 14th December 2020.
Now you come.
6 years.
yes.
You had all the time in the world to produce whatever you wanted before the learned civil judge, you refused to. What is the appeal on?
Not,
That's a-
Absolutely nothing in the appeal also. You don't raise anything in the appeal. Now you're saying that you have some materials and that, how can we look into all
But I-
this?
Even at the time of appeal also, you not produce all these documents. Now you intend to file.
no, no, I have already filed. Application is already filed. It's not before your lordships. That's why I'm asking for Monday or Tuesday, then Lord Lakshmi.
ಬಂದಿಲ್ಲ.
Lakshmi, have it Monday.
The request of land council for the appellant list on
Monday or Tuesday, any day,
27.
please.
5, Nagendra Naika.
some document of verification, they will come. If they bring, they will say that go and read. That is to be. Because of then we can consider.
Yes,
My lord, I am for the appellant.
yes, bank clerk. Cashier, misappropriation of an amount of rupees 1,35,000.
Yes.
Proved in inquiry, you also admit. Dismissed from service. Challenge is rejected.
No, my lord, please permit me to go through this annexure F, page number 123.
Hmm.
That was the showcase notice issued to the map on the alleged issue. Next,
There is an inquiry report.
inquiry report is there,
There is an inquiry report
Yes.
based on which proceedings are taken by the bank.
but in total inquiry report, they relied on this document only. This is page number 127.
127.
Yes, page 127. This is the reply submitted by me.
Hmm.
I have stated,
Hmm.
the bank has provided to the one P1 to the assist the cashier.
Hmm.
That P1 has stolen cash several times. Even I have mentioned there, when Padma was cashier 65,000, when Balasubramaniam was cashier 35,000, when another is 30,000, another cashier 50,000, that Rajasekhara was the sub-staff. Even
Hmm.
bank has lodged a police complaint against him. That is there in annexure.
It is my mistake that I took such staff into confidence and I suspect their role in the missing cash under the circumstances. I pray that my lapses may be condoned. I am willing to pay the money in installments, twice admitted in hospital for hypertension, so on. This is,
This is,
you say that there is supervisory lapse on your part. It is not the role of the sub-staff to account for the money. It is a role of the cashier. You admit that there has been a flaw on your part.
shortage of
You
cash.
say that I will pay the money. Now, please take us to the inquiry report.
in inquiry report, even you up to the appellate authority, they have everybody relied on this letter.
Please show us the inquiry report, Counsel.
Yes, that is there in page number 140,
67,
167,
67.
only 67.
No, no, 67.
67. annexure.
67.
Correct.
Type copy.
Typed copy is there.
Record mutual consent marked as only its 156 years and days or another document, etc. Management witness. Defense documents, produce document is taken on record, defense witnesses, defense neither produced any witnesses nor examined the CSE.
No, my lord, my reply is marked as defense exhibit only.
You did not examine any witnesses,
But no
you did not
witness,
produce.
no witness, but document, my reply has been marked.
Yes, your reply is there. What is your reply? This is the reply.
Same, that DX1, that page number 127. That's
He was argued as under so-and-so has valid counterfoil, branch found unaccounted challan.
Customers are examined, my lord.
Branch had reported the matter. So-and-so do not indicate any excess cash as per customer complaint, etc. Defense has neither contested this issue nor disputed about the irregularity in transaction, however confirmed that the CSE had issued counterfoil under seal and signature. Findings. So-and-so admitted the above. There is no denial of the fact that in the defense, therefore I accept the contention. Issue number 2, declared excess cash. Appropriate sum of 14,000. Yes, it is a finding on the basis of the evidence which was recorded in the inquiry.
But-
Therefore, you did not challenge the inquiry on any procedural aspect.
the basic mistake in this case is, my lord, I am a workman. I was entitled for relief under Industrial Dispute Act 11A.
You did not, you chose not
Instead of that, I with some wrong,
not to. You
with some wrong.
came here, you challenged it.
Yes.
And the challenge has been considered by the learned
But
civil
the
judge.
learned single judge has gone through the charge wise.
But we had taken the contention of, in my statement of objections, that there is an alternate remedy. In spite of that, my lord, he has taken a chance before the learned single judge.
I may kindly permitted to go to labor court at least.
No, my lord. 10 years, my lord,
So that the evidence,
matter was,
the evidence.
After having availed a higher remedy, you cannot go back to the lower remedy. Sorry. You've subjected yourself to the jurisdiction of this court under Article 226. That has been examined, found against. This is the end of it. And a cashier for misappropriation.
No, misappropriation is not proved, my lord. My lord, actually, what proved is
That what is admitted-
shortage of cash is only proved.
The basic concept that what is admitted need not be proved is applicable to disciplinary proceedings also. It may not be a criminal crime, but all that is required is preponderance, the proof on preponderance of probabilities. You You face a full-fledged inquiry. You do not point out any error in the procedure. That is all we can look at. We cannot go to the subjective findings of the inquiry. Is there any error? You did not raise any such contention with regard to the conduct of the inquiry or the conduct thereafter in accordance with the rules. Those are the matters the writ court can go into. The writ court considered it even on merits and said that there is an admission, that admission has been taken out of, nothing wrong. What can we do? The end of the matter. His appeal is filed. Challenging the judgment of the learned civil judge in the petition number. So and so. Judgment of the learned civil judge dated so and so in the petition number. It is stated by the learned counsel for the appellant that the appellant was appointed as clerk in the respondent bank on 6/4/1983. While he was working as clerk at the Neelasandra branch of the bank, he was kept under suspension with effect from 2008 on the complaint regarding discrepancy in cash remittance made by customers of the bank. It was alleged that there was misappropriation to the extent of 1,35,250 rupees and a charge sheet was issued to the appellant with regard to misconduct on his part in not crediting the amounts remitted to the respective accounts. The appellant had submitted a reply stating that there were issues with regard to the central banking, the implementation of the central banking system, and that there was, and since there was heavy rush, substaff had been sent to assist the appellant, and that the said substaff had misappropriated, had probably misappropriated the amounts. He said he suspects had probably misappropriated. It was submitted that the misappropriated them. However, the reply was not accepted and inquiry proceedings were conducted. After being found guilty of the charges in the inquiry, the appellant was inflicted with the punishment of dismissal. It is submitted that an appeal had been preferred, which was also dismissed, and the appellant had approached this court. It is further contended that the learned single judge had also relied on the reply submitted by the appellant and concluded that the appellant had admitted the charge and is not entitled to any relief. It is submitted that it is submitted by the learned counsel for the appellant, relying on the authorities, that is the list of citations, that the reliance placed on the conditional admission made by him in the reply was not proper, and that he was entitled to be reinstated and for the imposition of some lower penalty, even if the admission is accepted. Full stop. Learned counsel appearing for the respondent, on the other hand, contends that on a charge sheet being issued to the petitioner alleging misconduct and misappropriation, a clear reply had been submitted stating that the appellant suspects the role of the substaff and that he is ready and willing, and that he admits lapses on his part and is ready and willing to make good the loss which has occurred to the bank. It is submitted that the amount has also been remitted by the appellant. It is contended that though the respondent had taken a specific contention that the appellant had an efficacious alternate remedy of approaching the labor court since he is a workman, the appellant had argued the matter before the learned single judge, and the matter has been considered in detail and a judgment has been rendered. It is submitted that since no contentions have been raised as to the correctness of the procedure in conducting the inquiry, findings in the inquiry, which were based on evidence placed before the inquiry officer, are not subject to challenge in this writ appeal. Having considered the contentions advanced, we notice that, which is the charge memo
That he has not produced, my lord.
that
It is come in the inquiry report only. He has not produced that charge memo.
therefore it is there in the
It's there in the findings, my lord, first page itself, my lord.
that the charge memo had been issued.
Well, page 67,
Appellant.
then, my lord, page 68, my lord, the last paragraph. Charges against T. Mohan Raj. Page 68, my lord, in page 68.
Yes. That memo had been issued against the petitioner, alleging specific charges of cash shortage, irregularities,
Citations.
non-accounting of cash, and misappropriation of funds. The petitioner in the reply submitted by him, specifically stated as under. That is page number? The objection?
Our objection,
No, the reply, 127.
that is 127.
Yes. Specifically stated as.
And there is also another reply, my lord, which learned single judge has taken note of.
This. It's my mistake that I took some stuff into confidence as assessing their role in the missing cash. Under these circumstances, I pray that my lapses may be condoned. I am willing to pay the money in installments. This within inverted commas, page number 127, last paragraph. Next. The further, the learned single judge has also relied on a further reply dated
That is, my lord, dated 28/4/2008.
28th.
That is produced in the inquiry, my lord, MEX 14.
Used in it by the management. The learned single judge took note of the findings of the inquiry as well as the admissions made by the petitioner and has considered the contentions raised in the writ petition to come to the conclusion that in the facts and circumstances of the case, there is no error in the imposition of the ultimate punishment of dismissal in view of the fact that the employer in question was a bank and the employee was exercising, holding a position of trust in the bank as a cashier of a branch. Full stop. The contentions advanced by the petitioner were also taken note of. And the admissions made have also been specifically referred. Though the learned counsel for the petitioner relies on the decisions of the apex court to contend that it is only clear and unequivocal admissions that must be taken into account. We notice that the instant one is a case where the petitioner had been put on notice of the charges against him, and his reply had been taken into account and a full-fledged inquiry had been conducted against him. In the said circumstances, we are of the opinion that the findings of the learned single judge do not require any interference. The decisions relied on by the learned counsel for the appellant are decisions where no inquiry was held and a person had been dismissed only on the basis of the admissions made by him. In those circumstances, we are of the opinion that no interference is warranted in the judgment of the learned single judge. The appeal fails, same is accordingly dismissed. Those are decisions where there was only the admission. That admission was taken into account and dismissal. Here is a case where full-fledged inquiry, you have nothing to state against the inquiry. Conduct of the inquiry, how it is conducted, nothing. Therefore, and he has also admitted that even if it is a supervisory lapse, even if he had not actually misappropriated, how can we explain the loss of confidence? You should have gone before the labor court.
Even customers are also examined, my lord, in this matter. Normally, my lord, customers will not be.
You do not take the stand, do not examine anybody. Nothing. At least that person could have been summoned as a witness. The sub-staff. If you could have gotten anything from him, something would have clear, open and shut case.
He is absconding. Even after 2 police complaints, nobody traced him. That is the situation.
All that could have been produced in evidence.
No, that is that FIR is.
That he is absconding, that there were police cases against him. All that you should have adduced in your evidence. Nothing. Absolutely nothing. Yes.
Number 6, government advocate.
6. Yes, 6 is this matter.
Wait, madam.
Undervaluation.
Undervalued.
45A3. There is this is the judgment. The second one is the judgment.
Yes.
That is relied.
6.1 is the main judgment.
Yes, Shehnaz Bilal.
The thing is, pleadings are in this, there is the judgment, not that. there are two issues, my lord. One is on limitation. My lord, though I may concede that, though even I did not very strongly argue that, but the learned single judge has held in our favor so far as only 9 cases were concerned. The rest is on merit. Only issue is what is the interpretation of subject matter of the deed.
Next week it may be steps.
The 5th, my lords, I would only request a date, because what's happening is there is an interim order of stay granted by my lords. I have succeeded. I deposited 50%, my lords, before the
That you have to
appeal.
get back.
Now, because of a stay, they are issuing recovery notice. That's my problem. They have started issuing recovery notice, though we have given replies. Land recovery notices are being issued. They should not precipitate that because of a stay in.
Maybe next week will.
Yes, we'll take it up next week
Oh.
and please be ready on the questions next week because item 6.1 is the main matter. That is not scanned. We see that is scanned and put up. Yes, because that judgment also we don't have.
That's even I am.
It is there in the paper. Because I'm relying on this as much as possible, I could not see that judgment. Please see that at least the judgment is scanned, nothing else. Yes.
Some date.
In that matter, it is pending for taking steps also.
That's only for the petitioners. Many of them are piggybacking now, my lords. Some of them are represented. Your lordships can go on with the merits, my lords.
Meanwhile, I take the steps also.
You can attempt to take steps, otherwise we'll hear it on the merits.
Yes.
And decide when the steps can follow. Yes.
Date, your lords,
10.
10
please. Meanwhile, let them not, because I've got the notices. Recovery notices are issued pursuant to an interim order in a writ appeal interim order, then it's being, that's only refund can be stayed.
No, my lord, let it come on 10th, my lord, I will make a submission.
In the meanwhile, don't please instruct that
I will orally.
precipitate the
I will
recovery as against them because the 50% they've already deposited.
Deposited.
The learned single judge finds in their favor and says that the 50% has to be refunded.
These
Then
are,
how can you initiate recovery against them for the rest of the 50%?
and with an intimation to us, to the councils.
We take notice of that and say, or
We
will
have
you
the
instruct?
copies.
Or will you instruct?
That's-
No.
You cannot.
I will-
No, as of now, you cannot
Yes,
recover that
is.
rest of the 50%, you cannot recover under any circumstances.
I will
The
inform
stay is
them.
only for the
Refund.
refund of the amount.
Yes,
Please instruct them.
I
They
will
cannot-
instruct them.
Yes, the learned advocate appearing for the HCGP appearing for the appellant submits that no further steps for recovery under the Revenue Recovery Act will be taken.
Please.
He will appropriately instruct the respondents not to take any further action for recovery of the rest of the 50% of the amount under the revenue recovery. Yes. Please instruct them
I
appropriately.
will read.
Ask
I
them not
will
to
instruct.
precipitate.
I will.
Have it on the 10th. If you succeed in your appeal, that is another matter.
Right.
Number 7, Cyril Prasad Pais.
For the appellant,
He's a citizen.
overseas citizen, my lord,
He's an overseas citizen, also a citizen.
yes, ma'am. Section,
Yes, 5. 5.
yes, ma'am. 5 of the Citizenship Act. My lord, the benefit, this 7B, my lord, the rights what they don't have, my lord, is discussed there. So far as this is concerned, it was not discussed there at all. And my lord, there are 2 judgments, my lord, of the learned single judge.
Section 5.
7B, my lord, section 5, my lord, citizenship by registration.
Hmm.
7B, my lord, conferment
Or
of
citizenship by descent.
this, yes. My lord, here, my lord, she is the Indian,
Born outside India shall be citizen of India by descent.
yes, ma'am. She is an Indian citizen. She was a nurse working in the UK. She married someone there, and by virtue of her marriage, my lord, she obtained the citizenship of United Kingdom.
Question would be this. have you repudiated your Indian citizenship?
No.
Once you repudiate your Indian
It was
Indian
not.
citizenship,
No,
you will not have.
I will not. I
any-
have not
you will not-
repudiated, my lord. That was the reason.
You've
I-
not repudiated.
Yes.
How do you repudiate? If you take a UK passport, does that mean repudiation of your
No,
Indian
if I
citizenship?
take UK passport and if I don't register myself under overseas citizen of India, my lord, then it is repudiation, my lord. I have registered under myself and overseas citizen of India,
Section 7.
7B, my lord,
7.
7B.
Registered as an overseas citizen of any person who is citizen of another country, but was a citizen of India at the time of the commencement of the constitution, but eligible to become a citizen of India at time of commencement. 7D. You still hold the overseas citizen
Yes,
of
my lord,
India?
I'm all the card.
Yes. Admit. Oh, there's a delay. When notice is gone?
No, no, my lord, it's coming for admission.
No, delay is, in the delay also notice is not gone. Issue notice in the, in IA 1 of 2024 as well as in the writ appeal to the respondent. R3. Yes, SCGP takes notice for third respondent. Please serve copies.
Also,
The other two respondents are your children.
no, they are my, one is my niece and other one is niece husband, my lord.
Yes.
Hearing on IA, till number 8, Shakraya R3.
This was dismissed for non-prosecution for non-compliance of office objections. Kannada translations are much voluminous, my lord, therefore, my lord.
39/2022 is the order. 489 days in filing, recalling.
Written objection, not only translation.
Everything I will comply, but since file is not available, my lord, therefore.
Why after 489 days? What is the subject matter?
But subject matter of this, my lord, the BDA formed the layout, my lord. Thereafter allotted the sites. And I am the 5th purchaser of the site from my vendor, my lord. The owners have, my lord, filed writ petition. The Assam court, my lord, set aside the layout plan, my lord, but did not disturb with regard to the allotment made in respect of the parties, my lord. Since there is no resolution passed by the BDA with regard to farming of layout, my lord. Additional layout, my lord. Layout plan is set aside, my lord. Now, the owners claiming, my lord, the contention of the BDA, my lord, they have allotted denotified the property in western side. They are contending that southern side, my lord. That is the dispute between the BDA and the landowners, my lord. I am the purchaser of the site from the allotee, my lord. I am the 5th purchaser, my lord. I have put up residential house. My lord, now, my lord, knew of this, my lord, therefore I have filed impleading application. No orders are passed on my impleading application. However, my name is shown. BDA has also filed writ appeal, and the others also filed writ appeal before the Assam court. Those writ appeals are pending, my lord.
What is the reason for the delay? 489 days.
And after the dismissal, my lord, since, my lord, no orders are passed, my lord, after verifying it, my lord, I have secured the party, and thereafter, my lord, since party was also not well. Recall, my lord, since, my lord, I was under the impression the matter is pending, my lord. Only when I verified in the net, my lord, I was under the impression the matter is, it is bona fide. It is mistake on my part, my lord. Please, my lord.
If objection not complied, application.
My lord, 20 days, my lord, voluminous, so 2 weeks, my lord, so 2 weeks. No, my lord, 2 weeks sufficient, please. Last week it was, listed. Right, I'm,
It is not discussed. No,
my lord, I will,
Cost.
please,
Yes, cost. Exemplary cost.
reasonable, reasonable cost.
3,000.
My lord, party next,
Fast.
2000.
Further 2 weeks time is granted to comply officer. Take to and pay cost of ₹2,000 for legal service.
Right.
If it is made clear that if office objections are not cleared and cost is not paid, pending application stand rejected.
Right.
9.
Plus, I appear for the appellants in this matter, Milas.
Filed an application under order 16, rule 1A. Now it's a condition precedent that they have to show some sufficient cause for bringing in the witness before the trial court. The application or the affidavit does not contain any averments as to why this witness has to be examined, my lords, and we do not even know who this witness is and how this witness is even related to this case. And therefore, my lord,
Categorically stated in my application, my lords, the witness. What has happened in this case is, my lords, the will is of the year 1965.
Yes.
The executor of the will, my lords, she dies in the year 1982. After her death, my lords, the appellants are in peaceful possession. They are enjoying the property and all, my lords. In the year 2010, my lords, at the time of change of revenue, my lords, they have got the entry on the basis that they are the class 2 legal heirs of the executor of the will. It is only then, my lords, I will file a P&SE case. Will, my lords, is of the year 1965. The witnesses and the scribe of the will, my lords, all of them have expired. Now, my lords, the witness for the application which I have filed, my lords, he is the son of the scribe. He is ready to identify his father's handwriting as well as his signature in the will. One of the ground for dismissal of my petition before the trial court is, my lords, I have not examined any witness or the scribe to the will. And the second ground is, my lords, for dismissal of my petition was, as per section 295 of the Indian Succession Act, I have not converted the petition into a suit. It is, my lords, the court's duty to convert the petition once an objection is filed by the respondent. So that ground would not survive. The previous occasion, my lords, this matter was heard, and I had made a request that, my lords, now I will file an application. I may be permitted to examine the witness. Admittedly, my lords, the appellant, my lords, he is a physically handicapped person. He stays in Ramnagra. I have stated the same in my affidavit also. He, my lords, on the guise of
Petition, which is the present petition. Thank you.
one of 25. In fact, my lords, the children of the witnesses and the scribe are only senior citizens now, my lords. This is of the year 65.
lords, the trial court has completely conducted the inquiry, my lords, in the witnesses have been cross-examined. Nothing survives for the trial court, my lord.
Considered, my lords, they dismiss the petition as not maintainable and not.
During the course of the trial, petitioner has not chosen to examine attesting witnesses, but
Yes, madam.
after respondent's evidence, he filed an application, recalled himself and deposed further chief examination. In his evidence, he stated attesting witness to P1 is alive. Hence, he will examine him. The interest of justice, petitioner is permitted to take out notice to witness. However, even after several opportunities given to him. He has not made any attempt to secure the witness to P1 before court. Consequently, court as per order dated closed, further evidence of petitioners taken as nil and post for argument. Subsequently, petitioners have not submitted any arguments, not taken any steps for examination of attesting witness to P1 will. Prayer, petitioner sought for probate and letters of
Yes, my lord.
administration.
Probate and letter.
Petitioner has not made any attempt to clarify or to seek proper relief or to delete the prayer for probate. Being the present petition for probate is not maintainable. In view is not. At the time, an attesting witness was alive.
Yes, my lord. At that time, one attesting witness was.
You had ample opportunity, you
I-
were given time.
I agree, my lord. I agree, my lord. At that point of time, one attesting witness was alive.
When you have the opportunity, when you can, as a matter of fact, produce evidence, you do not do so. Now, in appeal, you come, you may have something with regard to the other aspect of it, with whether the prayer was whatever.
Yes, my lord.
At this point, you say that now the attesting witness is no more, but now there is a son of us cried. Are you entitled to that relief in this appeal?
Let's understand what has happened, my lord. Practically talking, I've produced the certificate also. The appellant, my lord, is a permanently physically handicapped person.
No, then this-
He
they have
stays in his,
So many material facts in this.
he stays in
In
Ramnagar district.
in a petition under the Succession Act with regard to proving of a will, are you entitled to any specific?
I agree, my lords. I agree. my
Benefit as a.
I had to
as a
examine one of
physically
my
handicapped
attesting
person?
will. That was my prayer in the last date of hearing, my lords. One opportunity may be given, yes, to him. Solely on that ground, my lords, I must not be, it is a registered will in the year 1965 itself. 1982, the executor will expire. I have been enjoying the property.
Prevented you from proving the will as you're very well aware, you're approaching a court for a
Yes, ma'am, for the probate.
probate or letters of administration. You know that the will has to be proved. You're given all the opportunity.
Yes, my lords. Happens is, my lords, to be off the record to mention, my lords. He would have instructed the advocate as per my information. But since he was staying at home, my lords, his impression was my advocate is taking care of my case, is taking care of my case.
Lord, that
Now,
is-
all of a sudden, he gets to know that no, my case is not alive, my case is gone. Then
What is the property involved?
property involved is, my lords, it's an agricultural
agricultural
land.
property. And my lords, his brother has gone and filed a
Totally.
suit against him and me in the Nelmangla court minutes. And he has obtained an order of stay also. That has not been explained in this petition. Furthermore, the same petitioner has already filed one more writ petition against the order passed by the AC and DC.
That is a revenue
That is also
proceedings.
still pending, and that also has not been explained in this petition.
Totally 6 properties.
Why would, this is not a repetition, this is an appeal.
You are also making some.
Why should he say all that in this appeal? This is an appeal directed against a.
Probate and succession.
so
Yes, my lord.
It is not a writ petition where he comes in, where he has to state everything. Not a
Correct. No,
discretionary
I totally
relief is
agree.
only.
The question is, my lord's point of for consideration is not whether the P&SE has to be converted into a suit or not. I am also completely on that point. But the point for consideration is whether this beneficiary can be even considered as an executor, because the trial court in detail has gone through the entire papers, it has conducted the trial and then has come to a conclusion that since he is not a he cannot be treated as an executor. Therefore, it is not maintained. That is the logic behind the order passed by the trial court.
Whether he's proved to be or not is the case.
What I pray,
That logic may also not be correct.
Yes.
what I pray,
Had claimed either probate or letters of administration, he had claimed.
Correct.
His prayer for probate, even if it is not found maintainable. The other question, if
Letters
the
of-
will is proved, then all the other questions are liable to be considered.
Correct.
Whether he's entitled to a letters of administration as a residual legatee, that question would have to be considered.
Correct.
But the will is not proved, that is the difficulty.
But
What-
even in
what I re-
now, even if the matter is remanded back, nothing survives for consideration before the trial court, because the son of the scribe is now coming and wanting to testify, giving us testimony
Yes.
before the trial court, which is.
if I may be permitted, my lords, that is the law laid down by the Supreme Court. If the attesting witnesses or any scribe, they are not alive, their children can identify his father's or mother's signature. Here, my lords, it is the son of the,
It was available even then. What
But-
prevented you if the
that is,
attesting witness was available then?
that,
Not.
that
no
mistake
steps
is
taken.
from appellant side. We are
The,
accepting that mistake.
Scribe's son was very much available.
Was
then.
available.
No steps taken. And now we have to hold that what the,
They had no instruction. To be frank, my lords, the appellant had no instructions with respect to that, my lords. That is why, my lords, my request is, a time bound may be fixed, my lords, 3 months or 4 months, my lords. We will adhere to the time.
filed your objection?
Yes, my lord, I find my objection.
We will adhere to the time, and we may, the trial court may pass appropriate orders.
Yes, we'll list it on some other day.
Please.
Just
And
after a week,
Meanwhile, may I submit my written arguments as well?
please. You could do the needful also. File a
Please.
synopsis if you want.
Please, my lord. Please.
18 orders. Number 10, K.M. Prakash.
Lord, I have served the copies on the other side. The office inadvertently has not seen the notice has to go, my lord. And the another thing, my lord, the order dated, I have filed a memo, my lord. Instead of mentioning the appellant, it has mentioned as the respondent, my lord.
For rectification of order dated 17/2/20.
And 17/2/23, my lord. No, my lord, appellant have brought the LRs of the appellant 1A. They are already on record. Appellant number 1B and 1C are the LRs, my lord. Have filed the memo on 3rd April 2017. The order passed on 17/2/23. There, my lord, it has
In the order.
inadvertently mentioned as
Order dated
respondent
17
instead of
to
appellant.
20. Yes.
Ah,
This is,
my lord, I have, yes, my lord.
Order dated so and so should be read as.
And there is also.
Order dated 17/2/2023 should be read as a, what is it, appellant, no?
Yes, my lord.
His memo is dated 5/3/24. His memo is correct? The earlier memos is correct, it is as appellant? Ah, no, that memo is correct, it is as appellant.
Memo is correct, my lord.
That memo is correct,
Yes, yes,
only
my-
the order
yes,
is wrong.
yes, my lord. 3/7/2017, my lord. That memo is correct, my lord.
Yes, yes. Yes. 24,
Grateful.
yes.
Eleven,
Only 2 weeks time will be granted.
Non-filing paper. 10/6/21, 25/5/23, 2015 RFA. Last chance,
Please, madam.
2 weeks.
Yes.
Weeks time the
Well,
record is
urgent.
announced.
13, Chetan B.
The amended appeal
Filing.
memo is ready, my lord.
Can be filed during the course of the day.
Yes.
The Learned Counsel for the
And-
appellant submits that the amended appeal memo is being filed today.
My lord, the matters are covered, my lord. Can I request for a date, my lord, 31st next week, my lord.
Yes, please give a date.
31st. 14. SGF there.
Just a moment, 13, there is a filing delay. Counter of it is also on record. Okay, okay, we'll consider it. Yes, sorry.
In this case, appellant number 1 died, my lord, in the meanwhile.
Yes,
Filed an application for IA 2/24 for bringing his LRs on record. And if that is allowed, my lord, I would like to amend the appeal memo and serve the copy once again to all the respondents, my lord.
bringing the LRs of the appellant on record.
IA 2/24, my lord. Listed today.
1/24. Yeah, 1/24.
1/20.
There is no delay.
Litigation fraud.
Listed.
The other observation. Lines of first, second,
Pardon?
What are the other observations?
Other application 1/21, my lord, the earlier filed it along with the application for dispensation, my lord. It was. And the appeal was filed.
Copy is not served until this. Copy serve ಮಾಡಿ.
Copy also.
Serve ಮಾಡ್ಬೇಕು.
You are a grantee.
No, it was purchase. Purchases.
Each time is granted to comply. Comply other office objections.
No, other objections only with regard to the serving of copy has been served. Acknowledgement was not filed in the office, my lord.
You are fine.
Now I will amend the petition and serve once again, my lord, entire petition.
Sir,
So
fine.
I will do that, my lord. And, 10 days time, it is.
Yes, 1 week.
Yes.
15, government advocate.
1 week time may be good.
Last week.
Respondent.
It is abated. Okay, no, granted, it is fine.
How I received the details of LR. I file necessary applications.
Sir?
I will file the necessary.
Technically abated, sir. File application for.
I will-
This court,
1 week.
today order dated 29/7/22 and 8/1/25. No steps have been taken. The appeal is already submitted against the respondent. Letter against the respondent.
File.
Right, for the- How it is dismissed what?
Not week, 1 week time may be given. I file the necessary.
File application will consider recall letter. Along with recall, everything. Can't one, unfortunately, from the knowledge we can give 1 or 2. They given twice.
Only,
Third time.
only today they given the LRs, details of LRs. I will make an application.
Right, for that. 1 week time is there. To do it one week.
One.
Release on Sunday. Date ಕೊಡಿ. On that day ಬರಲ್ಲ ರಜೆ ಮಾಡಿ.
5-2.
They miscellaneous work 2 hours.
So much of time has been taken.
16, Vaishali Hector.
For appellant,
Lords, on last week, my lords had directed whether there are two appeals or only one appeal. We verified from the office, my lords. There is a number given to other petition. My lords. That is writ appeal number 1128 of 2021. We have filed one appeal, but office has has given different number for other in respect of other appellants and the petitioners. My lords. We have filed LR application in respect of first appellant. First appellant in writ appeal number 1128 of 2021. First appellant in respect of WA.
Wait, where is 1128?
Page number your.
Linganna.
Profile application to bring LR.
Bring LR of appellant number 1 in 1128.
Even the rectification.
IA 1 of 2024.
One of 24. Second partial.
There is setting aside. 510 days.
Appeal
1128.
1128 of 21 is permitted to brought on record. Appellant shall amend the court title and file amended court title within a period of 1 week.
Please, my lords, there is short point involved, my lords. Next week, if date may be fixed, my lord.
Court officer, please say the two numbers also have to be shown. Shown only 1079. 1128 is also there.
We number 1128 of 21.
1128. And 1128.
Along with WA 1079 of 21.
Obliged.
If the numbering is they have accepted the numbering, then the numbering has to be shown.
Please. Obliged.
Format deputy.
Now 1 week time may be gone.
Protocol is required for government to apply steps to be taken.
Finally, for the plans, filing application seeking substituted service and also respondent number 14 passed away. I'm filing application to bring the LRs on the record.
What is the respondent number 8 and 9? File wakalat in the office kindly.
Then I am not pressing the IA. No question of issuing this substituted service. He is filing wakalat for respondent number.
R respondent number 8 and 9.
Your question, what is your name?
Sanjeev Rao, yes.
So, you file or you want to file?
It is ready, man. I will file in counter.
You undertake to appear for respondent number 8 and 9. In view of the said submission, registry shall show his name in the pass list after filing wakalat. In view of the same, the applicant will not take steps by a substitute service to the respondent number 8 and 9. Yes.
My lord, so respondent number 14 is concerned. I'm filing application to bring the LRs on the record.
And also for the applicant is permitted to file application to bring LRs are scrutiny on record in the registry. Please. Scrutiny LR. One set. This next. This.
After service.
Date may be.
Such applications file. Issue notice.
Please.
Much of.
Well,
19.
Both the parties have already filed Manoj the written submissions list of authorities as well. So there is some urgency. May I request Manoj to fix any shortest possible date?
what is the issue about?
Manoj, the issue is Manoj, I entered into a PPA with Manoj the BESCOM that was approved by KERC. Manoj, there was a tariff of 9 rupees 56 rupees per kWh. That was agreed in the PPA. Once when the KERC approved it, it approved that tariff subject to I commissioning the project within 1 year.
Hmm.
So I proceed with the implementation of the project.
Hmm.
Just before the commissioning, the KERC reviews its own order saying that we could not have granted 1 year and it should have been 6 months. So they review that order and then they now reduce the tariff to 5 rupees 20 paise. So that's the reason we went before the learned single judge. Learned single judge has quashed the KERC's order.
Submitted by the learned counsel for the respondent that the written submissions along with judgments have already been made available. You've got the copies, written synopsis. So when do we want this? When do we hear?
Tuesday, if not considered this one.
The, when they have, give the matter, the office objections can complied with, list on Tuesday.
Tuesday, please. Great.
Grateful.
20, Gautam Dev,
My lord,
PDA.
my lord, this was
R7.
notice, my lord, when this respondent number 126, my lord, I was permitted to take notice to their counsel single before the learned single judge, my lord, and now that if the order may be issued, my lord, to permit notice again, my lord. If not, office will not issue notice.
In addition to the previous one.
Because next time it came as compliance of office objection. 2 weeks time was granted to comply office objection, but there is no office objection, my lord, so I could not take notice to.
R8, R9, you've taken notice, returned unclaimed. That
But,
can be,
just for
that can be-
representation, my lord, I'll serve the counsel.
yes. What about R7?
R7 and my lord,
R7 reported dead.
Yes,
So
I'll take,
please
yes, ma'am.
take steps. R1 to 6 also.
Yes. I'll
Have
serve
to-
the council also.
that may
Okay.
not- You have to take out notice. In addition, you could have.
My lord, what happens if the council comes, my lord? If the council comes, I will know R7's LRs also.
If the
If a council, yes, my
the
lord.
council does not.
I will call him, I will coordinate and do it, ma'am.
Unserved respondents.
Yes, please take steps for the
They
answer.
have 1 week.
21, Ashok B. Patil,
I am for the appellant. I pray for a week's time in this matter, madam. My senior is not well. It may be taken up in the next week.
I prefer respondents 1, 2, 3. A small matter, my lord, notice issued by the BMTF, asking them to produce documents in the to investigate a complaint filed by respondent number 5, my lord. Their contention was BMTF is not in, the term of the BMTF has expired. But government advocate has produced the documents to show that it is extended. my
It is still there,
Yes.
still in existence.
Next week.
Yes,
Next.
it has to be heard. now.
In process. Yes.
Give a date.
Weeks time.
Please give a date.
7 to
Please.
22 Arjun, 23,
But I was directed to serve copies of the appeal and the application on the respondents. I have not done so. My lords may grant me some more.
Weeks time. Please do it in the.
Yes,
in the-
positive.
Anand B.
24. Appellant, my lord.
And it was.
With
Delay.
regard to R4, I already served the R4. KDB, I served the copy to PV Chandrasekhar advocate. Chandrasekhar. Morning idri. R1 deceased.
This is plus of submission based on IA3 of,
I,
this is the R1.
R1 already filed applications, 3 applications, section 5 and 22. Run?
Set of the applications.
Fine, I'll file. Allah, division confusion. Second set ಹಾಕಿದ್ದಾರೆ by mistake. ಹಾಕಿದ್ದೀವಿ ಅಂತ ಕಲ್ಲಿಗೆ ಹಾಕಿದ್ದೀನಿ ಅಂದ್ರೆ by mistake.
ಕೊಡಿ ಇವಾಗ್ಲೇ ಮಾಡ್ಕೊಂಡ್ ತಂದ್ಕೊಡಿ
ಅಲ್ಲ ಇನ್ನ ಕಂಪ್ಲೇಂಟ್ಸ್ 1 week time.
ಯಾಕೆ ಒಂದು
ಅಲ್ಲ ಫೈಲ್ ಮಾಡಿಸಿ ಬೇರೆ ಎಲ್ಲ ಇದೆ ಇಲ್ಲ.
comply give one set, second set will issue notice on that application. For that filing 1 week, then issuance
Okay,
of
no.
1 week,
No one day.
pass over market.
ಕೊಡ್ತೀವಿ.
1 of 23.
3 of 24, 2 of 24.
And 3 of 23 also is there. 23 is of 24.
25, Rachita Rajshekar.
Does anything survive?
It survives because admissions have been made, but proposed impleading applicant who has, my lord, obtained a seat is sought to be made as a party. I only pray, my lord, there are some deficiencies in the application. It may be permitted to be served physically.
Required. Can it be considered at this after admissions?
My lord, we were entered that seat is given to him is the case. We will notify him personally, my lord, because of that it's pending. Once your lord, he comes, my
Week's
lord.
time to comply with the office objections. Week's time.
Twenty-six, Dilip CJ.
May it please the honorable court.
What is the office objection?
The office objection is there is only prayer. That is only one prayer. It is broken up into one prayer.
Yes.
The honorable court may recollect that this was the matter in which the third respondent had passed the order granting conditional permission for 42 seats. And thereafter, Union of India has issued an order. I think it's the same date because they had availed multiple remedies at the same time. And Union of India has denied permission.
My lord, it comes from my lord because my lord is to pass an order 28/11/24 on the submission also by the government responsible.
Have you produced all the material?
It,
Office objections or the IA are dispensed with for the list.
only the extension of time. On 8/1/25, they opened the portal till 13/1/25 for 5 days. Within those 5 days, my lord, we are not able to fill up more seats. We have requested them to open it for few more days. That's the urgency. Because 38 seats are filled.
Can we list this tomorrow?
Who has to do the commission?
Monday, my lord.
Okay, we are appearing for the, my lord, ultimately, my lord, the central government's order, my lord, is this Monday, lord.
Monday.
Give instruction.
No.
make statement.
Wait for
Yes.
Please get instructions. Tell
I'll
us
take
what can be done. Yes.
That's for Union of India,
Yes.
respondent number 1. I'm filing the second appeal.
The
That is
order.
the order of the second appeal.
Order they've already produced, haven't they?
Yes.
Haven't they produced along with the IA? You can make it available. There's no difficulty. Please be here when the matter is called on Monday.
I'm appearing on behalf of the CGC, my lords. He will be present. I'm appearing on behalf of the CGC, Madaran Pillai. He'll be present.
Of course. It's better that it is.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಹೋಗ್ಲಿ ನೋಡೋಣ.
From their IA. That is what they're relying on.
ಮತ್ತೆ ಆಮೇಲೆ ಅಷ್ಟೇ.
Oh, listen.
27. Atma Devi Hiramach.
Lord, on the last occasion, I had sought for some time to verify whether they are allowed, they are permitted to.
They're permitted. In service quota only they are permitted. Not in, as in service.
Some benefits are given as
You-
service candidates.
We can record that and close these matters.
It's been.
And this wrong.
Is there any problem there?
No, this is what I'm trying to say, my lord. Sometimes when we say it, my lord doesn't catch what is happening with our experience, what we have seen, my lord. My lord, I asked this question to my learned friend that from where did these seats come? If in-service quota is to be, because it was already notified that this has been decategorized. Therefore, from where the seats have come? And my lord, no, wait. My lord recollects, yesterday I mentioned the other day in that other matter where some seats were not disclosed. So whether these seats had been decategorized and also notified in those rounds.
That we'll
From
see
where
it
did-
on case to case basis.
No,
We
no,
can't
no,
assume anything. No, just a moment, just a
No,
moment.
from
What
where
does-
these seats
what
have
does
come
this
now?
order say?
They have got some, then go.
No, what does it say? I don't understand. What does it say?
Nobody is opposing it. We are not opposing it. Nobody is opposing it.
What, please tell me, what does it say?
No, my lord, with respect, nobody need be. I am not opposing also.
Just a moment, yes.
Under the general code, for in-service candidates,
Hmm.
we will counsel only from the list sent by the government.
Correct.
These students, the percentile was
Lowered.
reduced,
Ah.
they were not there in the list earlier.
Correct.
Now government has given the list.
Ah.
We will counsel them. But in the general quota.
What about,
the other 4-5 petitioners?
what
All
about,
general.
what about,
All are permitted to.
everyone is permitted?
And all their.
Everyone, everybody.
Oh,
That cutoff, decategorization is again decategorized.
decategorization has to be held up.
What your lordships have indicated, my lord, by virtue of.
All that was not,
That's only.
no, but still in those matters, we must say that in the next year at least, some coordination must be there and something must be done so that students are not put to this difficulty. If you are giving them some benefit, let them enjoy that benefit. Now you have ultimately at the last possible moment, you have now given them the benefit
this-
that they were seeking.
My lord, I had read this in the 19-1 or 19-1 order by why I asked this question to my learned friend. This is what has come from the KEA. It reads like this. Mop-up round seat allotment to PG for the year 2024 will be conducted through online. As per the directions of Honorable Court, government, competent authority, whatever, one round of seat allotment to in-service candidates has been completed. Semicolon. Unfilled in-service seats which were decategorized as per norms or roster system have been allotted to non-in-service candidates based on merit in the second round itself. From where have these come? So, my lord, with greatest apology, my lord, I often say these things. I have also said this thing to the court. I don't want to go into this in detail, but I want to just say this much to my lord. With my lords, it's a delight to make submissions. But please keep these factors in mind when they have said it is all over. Where this will come from, I am just telling this off the record. These are the seats which were not really decategorized. These are the seats which are not in that seat matrix. No, I am not. It is off the record, my lord. Take it, dump it.
No, if
With
we are-
apologies.
If we are considering.
With
this, then
apologies
we'll
for
have to
wasting
ask them
my
to
lord's-
Get instructions also and we'll have to hear them.
From where
don't
these
got
seats
it.
will come?
Yes,
No, please take the benefit.
the learned counsel for.
I am
the
not opposing.
petitions.
Nobody is opposing. We are not opposing.
It is allowed.
That is what we have given. We have not given any.
The learned counsel for the appellant, the petitioners in these writ petitions submit that a communication has been issued by the Karnataka Examinations Authority on 23/1/2025, permitting the petitioners to participate in the mop-up round in the in-service quota.
In-service.
As in-service candidates, as in-service candidates,
But as regular candidates.
as, no, they can,
Yes. No, we have not, once it is decategorized, we have not.
yes.
We have not given all that.
It is
Problem
it
is
is
Nobody is
submitted
stopping.
by the learned AGA that the permission is
Allow us
granted to the petitioners to participate in the mop-up round. And that nothing stands in the way of the petitioners participating in the mop-up round. The said submissions are recorded. Do you want this closed or do you want it listed along with the other cases? Do you want it closed or do you want this listed?
Now, since the learned friend is raising some objection to it.
Not me, not
No,
me.
no, I am not.
They have to do it as per what they now learned.
Not since there is a communication, I don't think any directions are required. My lord may leave it at that, post it. Let us see what happens.
Rest of the matters.
Can just
are
allow-
on
Yes,
third.
list along with the other matters.
Other matters.
Other matters. What it says, it says. We cannot improve on that. What it says, it says.
Otherwise,
Therefore,
like,
yes,
we'll have to keep.
list along with the connected cases and we'll deal with them all together. Fine.
So some of
Yes.
the notifications,
Date is already there.
some notifications which are issued, my lord. Between yesterday and today, we are not even having it.
Yes.
What is adolescence?
Okay.
Marking of qualification criteria, where the efficiency marks is also allowed to be, we also be taken.
No, that is not there in law.
List along with the connected cases. Yes. Yes, the date is already given.
Already given a third.
Yes.
Third of it.
It's. They should have. Hmm. Yes. We can finish off and then take the habeas corpus. Who appears in the habeas corpus matter? That is in the part. Who appears in the habeas corpus matter? They have not appeared. Yes. If they are there, we if both are there, then we call the habeas corpus.
Passed on matter. List. 2. So number 1, Avinash V.
The respondent statements.
Correct. T2.
Yes.
Final hearing, list 1, so number 28, Farah Fatima.
Yes.
But 3 new contentions have been canvassed, my lord. Only those 3, my lord, I know, my lord, we can't keep on.
Yes.
troubling your lordships, I prepared a short note of it. First contention is that, my lord, suit is barred by limitation
Yes.
because, my lord, of the two letters, exhibit D2 and D3,
Yes.
which are, my lord, at pages 401 to 405 and 409 to 413 of the first contention, my lord, I have listed it out.
Yes.
Perusal of these letters, my lord, clearly indicate that they were willing to execute the lease deed, subject to certain changes. Therefore, my lord, it is not an absolute, my lord, denial. And more important is, and my lord, I did mention to your lordships, their own witness, general manager of, my lord, hotels, specifically says that, my lord, it is only, my lord, when they issued the legal notice. Serial number, my lord, 2, if your lordships look at, unequivocal denial, my lord, is absolutely essential. Sorry, my lord, in Roman 2, my lord, in the first page. Sorry,
Yes.
first page, Roman 2. I had given to your lordships, my lord, 2 judgments.
Yes.
There's another judgment of Justice Lahoti, my lord, as he then was, my lord, sitting in the Madhya Pradesh High Court. I'll, my lord, prepare a compilation. I, my lord, because of the paucity of time, I couldn't, my lord, prepare one. Once, my lord, I'll make 3 judgments I am giving to your lordships. Lord, this is under section 58 of the limit, article 58 of the Limitation Act, but the language is similar. That is also for declaration. 54, my lord, is specific performance.
Yes.
Please see, my lord. It note itself and then paragraph 7.
Yes.
It is common plea that the learned counsel of the party that the suit insofar as it relates to declaration shall be governed by Article 58 of the Limitation Act, which prescribes a period of 3 years commencing from when the right to sue first accrues. It is right law that limitation would not commence unless there has been a clear and unequivocal threat to infringe the right claim. Similar, my lord, is the language, almost similar is the language in Article 54. Para 10 also, my lord, their lordships hold. It follows from the above said authorities that distinction has to be drawn between a mere denial of the right or ineffective or innocuous threat to the plaintiff on the one hand, and a clear and unequivocal threat of infringement or the right asserted by the claimant on the other. Language, my lord, between Article 54, my lord, which refers to, my lord, which relates to, my lord, specific performance, and this is almost similar. Therefore, my lord, my submission to your lordship is I had given to, my lord, 2 judgments, my lord, earlier in my compilation. 32 Lahore, my lord, division bench and 14 Calcutta division bench, and this is, my lord, the 3rd judgment I am giving to your lordship. More important is serial number 3, my lord, Roman 3. Respondent's witness, he, my lord, categorically stated that till the issue of legal notice by the defendant, there was no outright refusal, and that legal notice, my lord, para 5, Roman 5.
Yes.
In fact, more important is Roman 4, my lord, if your lordship see. In para 6 of their plaint itself, for eviction, it is clearly stated, appellant company ultimately decided to terminate the tenancy by issuing the notice of termination. That's, my lord, the legal notice. So, my lord, this first contention, my lord, is not tenable. Second contention is, we have not sought for declaratory relief, my lord, and they rely upon one judgment. In fact, my lord, the judgment of the Honorable Supreme Court, latest judgment of the Honorable Supreme Court, in 2024, para 22 to 25, my lord, this very question is considered. Paragraph 22, my lord, my lords get that at page 16 at the top, my lord, your lords get the page numbers, short, small letters, sorry. Para 22, my lord.
Yes.
Absent prayer for declaratory relief, the termination of the agreement is bad in law, whether a suit for specific performance is maintainable. What their lordships hold is, you must raise it at the first instance in the written statement itself. This question has been considered by the court in I.S. Sikandar versus Subramani and answered in the following words. As could be seen from the prayer sought for in the original suit, plaintiff has sought for declaratory relief to declare that the termination of the agreement of sale is bad in law. In the absence of such prayer by the plaintiff, the original suit filed by him before the trial court for grant of decree of specific performance in respect of the suit for schedule suit scheduled property on the basis of agreement of sale and consequential relief of decree for permanent injunction is not maintained in law. I.S. Sikandar was followed by this court in Mahinder Kaur versus Sant Paul Singh, where on facts it was also held that the relief of specific performance being discretionary in nature, the respondent be held to have established his case for grant of such relief. However, in the interregnum, I.S. Sikandar was also considered by this court in Kantamani versus Nasreen Ahmad, and it was held that the former decision turns on the facts involved therein and is thus distinguishable. Sikandar is what they relied upon. In the latter decision, this court also held that it is well settled principle of law that the plea regarding maintainability suit is required to be raised in the first instance in the pleading in the written statement. Then only such a plea can be adjudicated by the trial court on its merits as a preliminary issue under Order 14 Rule 2 CPs. Once a finding is rendered on the plea, same can then be examined by the first or the second appellate court. It is only in appropriate case where the court prima facie finds that mere perusal of the plaint allegations that the suit is barred by any express provision of law or is not legally maintainable due to any legal provision, a judicial notice can be taken to avoid abuse of process of court, judicial process in prosecuting the suit. However, much was not the case therein. What follows from Kantamani is, unless an issue has to maintain framed by the trial court, suit cannot be held to be not maintainable at the appellate stage only because appropriate declaratory relief has not been. In the instant case, there is not a whisper in the plaint, in the written statement. More important is, in the companion suit, please look at my note. Look at page 3, para 5, Roman 5. Since both the suits were clubbed together, issue regarding termination, one other issue raised is, in that suit OS number so, one other issue raised is whether quit notice is issued, that is termination is valid. Issue number 1 in the suit OS number 5975 is as to whether in the second suit, whether or not termination is bad. This issue also is held in the negative, namely the termination is not valid. And therefore, this issue also is answered in the present contention. Is an answer to the present contention raised. In the suit OS number 1459 of 2006, the issue raised is whether the termination of tenancy is valid, which issue also is held in the negative, para 66 or paper book in RFA number so on. Therefore, these issues are a complete answer to the present contention. One is 2024 SCC. Second is the companion suits, all these have been considered. And more important, thirdly, this is a third limb of argument. Supreme Court has held, though we may have asked, not asked for a specific relief. If I ask for other reliefs, then the court can grant. I'll just pass on, one judgment for my Lord's consideration. AR 1962, Supreme Court. We have sought for other reliefs. Grant such other and further reliefs. Of course, this is my third alternative argument. Para 4, if your lords is come to. 4 lines from the bottom of just above para 5. The petition, however, was not amended. We may incidentally mention that apart from the reliefs above referred, appellant claimed 2 more reliefs, one of which was to pass any such other and further order that may be deemed fit and proper. Then, please come to paragraph 10 and 11. This, their lordships of the Supreme Court have held. If this is there, court can always mount the relief. Please come to para 10,
Yes.
It is true that the petitioner has already stated, confined himself at the stage of arguments in the High Court to the relief of abatement because change of circumstances which took place between the date of his filing the suit and the hearing. He did so evidently upon misunderstanding of the legal position with regard to the scope of notification on 16/3/25. However, appellant has raised an alternative contention in his statement of the case in effect that roadways buses which carry passengers are used to by the government for carrying a commercial undertaking and that therefore they do not come within the exemption made by the notification year 1925. In view of this and of the fact that the petition which contains a prayer for grant of other relief has not been amended and is thus in its original form, we see no difficulty in granting appropriate relief to the appellant. In the result, we allow the appeal, set aside the judgment of the division bench, single judge. So all that I'm saying is, my lord, this is an alternative third content, my lord.
Yes.
Lastly, my lord, stamp duty, my lord, they have raised it for the first time. That, my lord, it's an agreement. Therefore, my lord, it's not, my lord, there is no transfer in present. Therefore, my lord, the stamp duty is as per agreement, my lord, in terms of sections, Article 6, and my lord, we have stamped it as agreement.
Objections.
Yes.
This contention about stamp duty is also not taken in the written statement.
Yes. Yes, please.
Section 34 and 35.
Hmm.
Now I know that admissibility I cannot challenge. The 33. So there was no objection right during the passing of the bill. But as per the recent bill under 34, 37 and 39 of the Karnataka Act, the document can be imported. Document has to be imported. It is the duty of the court to import the document. Whenever the insufficiency of stamp duty would be observed. Just because I have not raised the objection, that doesn't mean that they can avoid the fiscal listing, because it's in the fiscal obligation and it's a revenue for the state. Okay. With regard to Article 30, my lord, of 1990 Act, Amendment Act, it clearly says, my lord, the lease involved and for the future rate also. And another says that agreement of lease is not part.
Yes.
And underneath or something or any agreement to let or sublet. Here. A speaks about when the premium is not paid, my lord. In that C states when the premium is paid, what is the lease? It says that when the premium is paid, the lease in section Article 20 equivalent to the conveyance of the premium paid addition to the Article 30 clause A where the lease of the rent is not fixed. Which comes to same duty as conveyance number 20 for the market value equal to 4 times of the annual rent fixed plus the advance amount paid. Should be the stamp duty paid. Where the exemption is provided in any case an agreement to lease stamp with the advance stamp required for the lease and lease in pursuance of such agreement is subsequently executed, the duty on such lease will not exceed 225 rupees. Article 20 states for a term exceeding 30 years, the lease is for every 500 of part that excess of rupees 1000 is 50 rupees, 10% above the value of 1000 rupees. So they have to pay the stamp duty on the premium plus the annual rent. As on the date of the 86 is not 29. That is not amended in 1990 for me by that. There's no amendment. But we want to argue that stating that there is no rejection, refusal. There is a conditional. But what is the condition, my lord? I have asked for 2 shows, bracket 2 shows. So it is admittedly for the 6 floor, I am not agreeing for the attribution of the rent. And I asked for the increment of the rent, which I clearly state in the next year, I have clearly stated, if these conditions are not fulfilled, I am not willing to register the lease agreement.
Yes.
So that is a clear refusal on my part. The termination does not, termination I have argued yesterday in a complaint. I can terminate at any time. But my refusal there, first reason for the thing is the refusal. Where I told I am not executing P1 and P5. And one more thing, the board had asked the respondent to clarify what is the amendment in the thing. Because they what as amended the lease fee, but nowhere in the pleading they have whispered what is the amendment. When they have admitted there is an amendment, they are seeking to execute the old lease fee. The pleading they have told that it is amended, and there is also as amended, exhibit P1 and P5. But that what is that amendment is not whispered anywhere in the pleading.
There appears to be a prayer, the plaintiff says, the agreement dated so and so as amended. And it refers to some amendment in 1992. There does not appear to be such an amendment at all.
Just take out the original plaint. Yes, if you have.
Page 15 of the paper books, huh?
It's amended also. It's
Doesn't. No, sir, doesn't. Ah, here. Said agreement as amended dated.
(1992) is what is referred. 1992, the letter that we saw has nothing to do with any amendment.
There's no amendment. I don't know what it means. I can only say this. Entire market value is in their pocket. They were agreeable to sell the whole property. Now, even 99 years lease also they don't want to give. They want to take away the property with the money. Ultimately, justice is more important than law. Looking at it, any.
Here, 8781, they refer to para 5.1, which refers to the earlier judgment of the Honorable High Court of Karnataka. Here, Amna versus Putama.
Rather notice. Currently 1992.
In an agreement or a deed of lease related to the present demand, that is, grants creates lease to the demand to create an instant by way of lease, either from the date or from the future date. It requires the stamp duty as per Article 30 and requires to be compulsory in this paper, irrespective of the period of lease being more than or less than 1 year. On the other hand, the agreement merely agrees to grant or create the lease includes subject to fulfillment of some conditions for absence of some contingency, which is single agreement liable to the stamp duty under residual Article 5. Here, the respondent has to prove what is the contingency. As pointed out yesterday, if I did not hand, they have paid the deposit, advance of 95% is already paid to me. The commencement date is fixed from 1986. If I don't hand over, I am liable to pay 80% of the interest for the deposit. And if I hand over, ask them to take the possession, and if they don't take possession, the agreement has to be fulfilled by taking the 5%, remaining 5%. The commencement date, there is no doubt. Here, the future date has no contingency in all the citations referred by the respondent. There is a contingency. In the first citation, they refer Food Corporation of India. There is a contingency where the Food Corporation says, my officials have to come and visit, and only after satisfaction. Most of the judgments, all the courts follow the judgment of Tribunal versus Srimati Leela Bayan. But one part in the judgment is nobody is following is the 16th part, where the court has said if there is no contingency, that is present demand.
Yes.
Para 15 and 16 has to be read together. And in para 16 for 15 and 15 for the clarification of the judgment. In concluding the document, it is necessary to remember that it has been executed by laymen without legal assistance. And so it must be legally construed without the impose of technical consideration. The ethic of the document too relevant to not determine its character. It is true that an agreement would operate as present demand, although the terms may commence at a future date. Future it may amount to present demand. Even though the parties may contemplate to execute a small formal document in future, in considering the effect of the document, we must inquire whether it contains unqualified and unconditional words of present demand and include essential terms of peace. Generally, if the rental will be payable under the agreement from the date of its execution and other specified dates, it may be said to create a present demand. Another regard is to intention to deliver the possession. If the possession is given under the agreement and other terms of tenancy have been set out, then the agreement can be taken to be an agreement to use. As in the construction of the other documents, so the construction of an agreement to use result must be had to all the relevant material and terms, and an attempt must be made to intercept the relevant terms if possible, and not to treat them as idle circular thread. The learned attorney general maintained that this document is not contingent grant of this. According to it, evidence of the grant of this subject to the condition, and that shows the present demand intended by the parties. Four lines below, my lord. In our opinion, it would be unacceptable to include this recital by themselves apart from the other recitals in the document. We cannot lose sight of the fact that document expressly stated respondent shall become the owner of the land from 1/6/1944, and the defendant would not have any title over it after that date. This recital also repeated in the later part of the document, makes it the intention of the party clear that it is only the assessment of debt is paid by the defendant. There are all the citations where the court has said to the future is not a present demand. Only that should be a contingent. In some cases, the tenant has to be evicted and placed. The privy council has told in India the litigation is high, so we cannot expect the contingency to clear so easily. So we are not willing to treat it as a contingent cost. But the Act itself states the future lease is of the present demand. This includes the future lease and it is a present demand.
Yes.
Only subject to the contingency. If they prove there is a contingency in the agreement, only then they can say it is not a present demand.
Yes.
That amendment.
Yes.
If your lordship look at my lord, page 3 of that claim, for a minute, I'll tell you, lordship, that must have been, my lord, what? Probably, my lord, they were discussing, ultimately, my lord, it crystallized into, my lord, those two agreements. Please have a look at that para 6 of the claim, my lord. I'm also not able, my lord, because for the first time they have raised it. We can't even ask, my lord. I tried to find out, my lord, who was there at that time. One person was there, he had some vague memory. He says, look, we were agreeable to execute the purchase. They went back and then they said, no, we'll give you now 199 years lease. I don't know, my lord. Now please look at page 3, para 6, bottom. This is, my lord, in that 849. In part performance, said the agreement dated so and so, as amended here and after the agreements. Agreements are, my lord, what we have produced. So, my lord, what they are referring to, my lord, are those two agreements itself. Probably, my lord, they must have earlier, my lord, they had something and then they amended it. So this is, my lord, the finalized this thing. If your lordship now look at the prayer, page 15, obligations under the said agreement as amended, dated so and so, so and so. For my lord, it is these two agreements only. There's nothing.
Yes.
Like it is not.
Sorry. Please,
Yes.
my lord.
Yes. Reserved for judgment.
We'll do it tomorrow. We'll take it as a group.
Yes.
The judgments, I'll put, my lord, I'll tag it along with that small note also, with your lordship's leave,
Please.
my colleague. my lord.
You have already filed a comprehensive synopsis. Yes.
Bill number 29 adjourned. Bill number 30, Udita Ramesh.
Going for the respondent.
You can. As a matter of fact, we have too many matters which we have reserved for judgment. We don't want to start another one. Sorry?
Yes, sir.
If I may kindly make one small
Yes.
submission, my lords. My lords, the matters, the dispute arose in the year 2006. Hence, a short accommodation, my lords, if it can be taken up this month itself. Very well,
Yes.
very well.
Just after 2 weeks.
20th.
2 weeks, 2 weeks. Yes.
Bill number
Great.
31, A.B. Gangadrappa.
Same. The same situation arises here also. We don't want to take this up and consider because we have three
My lord,
reserved
if-
matters at the point.
my lord, I have filed an application in WP 44709 of 11. Two writ petitions are connected with RFA. My lord, this application is to detach these two writ petitions from appeal, my lord. That application may be.
Is that objective? Yes. Mm.
This is.
Mm. 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 Clear gift. Mm. A personal land gifted to a temple. Mm. Mm. Mm.
Now, the person shown in the application is not represented by any person. Skeptical is that, and we came to know of having passed such an order. Then, I was thinking, because before the Karnataka application, personally, about it, and then not in number. Therefore, the application did not have any jurisdiction. So, the first one made by the Karnataka application to exclude the land relating to record relating to confirmation of occupancy and not. Deputy Commissioner filed an affidavit. Concerned Tahsildar filed an affidavit stating that there is no record. Now the other term is that in the affidavit that there are no applications for confirmation of occupancy. The tribunal does not take in case at any time the records are based, it is always open to others before the Karnataka. revive the appeal. Here, we challenge the entity before the result commission. A submission was made on top of the contesting response that there are records. Now the result commission found that there are no such records, and we is going to go ahead and take further decision. But either that is, having heard that the land is not enough, and it did not get it to government, and there is no question of proceeding and the answer. The state commission after that, stating that to enter the name of the government in the records and the process. That was challenged before the deputy commissioner. During the course of inquiry, an application was filed by the contesting response stating that at some point of time, there was a government record. Therefore, he produced his own only by copy of the gazette stating that some land has been given to. On that basis, it is considered that it is not that. So, whether it is not that or and our primary contention before that it is not an income land, it is a land that has been invested.
What is the first RFA?
Yes, that is. We are also violating before that it is not an income land. There is no deal. There is no question.
Declaratory suit. Suit for declaration.
Then we approached the Karnataka to revive the appeal. And the appeal was revived and the Karnataka whatever the order was to the reminded the matter to the and they are
My lord, appeal was revived the moment original records of Special Deputy Commissioner Inam Abolition was traced and placed before the Deputy Commissioner. Now, my lord, the entire case of appellants before all the tribunals was, these proceedings had never taken place. My lords, finally, my lords, one day, the government produced documents.
Therefore, the question is this, RFA also is on the question whether it is Inam land or not.
No, my lord.
They have to be heard together.
My lords, my lords, there is a thin distinction, my lords, because, my lords, the order passed by KAT, wherein the orders passed by Special Deputy Commissioners, Special Deputy Commissioner Inam Abolition was directly under challenge. My lord, appeal was partly allowed, remanding matter back to the Special Deputy Commissioner. My lord, now fact stands like this, my lord, that Special Deputy Commissioner of Inam Abolitions had passed an order way back in the year 1974-75, which came to be challenged in 2010 or so. My lords, now, my lords, this KAT order I have challenged before this honorable court in writ petition. My lord, both the writ petitions, my lord, are touching the question of orders passed by Special Deputy Commissioner. My lord, in the event, writ petitions are disposed of by this bench, my lord, then appeal lies to Supreme Court. My lord, in the event these petitions are to be disposed by the single bench, learned single judge, my lord,
The question,
writ appeal lies.
if the question is the same in the RFA and the writ petitions, then we can't have multiplicity of orders.
My lords,
If
matter-
suppose the writ petitions hold in your favor,
Yes.
that there were records and that it was an land. And suppose the appeal in the RFA, it is held otherwise, what happens?
my lord,
It has to be heard together, that is all.
In the
We'll hear it together,
my
yes.
lord, in the original suit, my lord,
After 2 weeks,
my lord,
we'll
just,
see.
just may I take,
We'll consider your contentions when the matter is being heard.
my lord,
Let's
above-
not have a full-fledged argument on the tagging.
Lord,
We'll hear
my
it.
lord, may I
If
make
as a
one-
matter of
may-
fact, there is any distinction.
May I make just one submission regarding the suit, my lord?
Yes,
In the suit, my lord, they are claiming individual personal right of over the property. Their Inam proceedings are not directly in question.
yes, we'll consider.
My lord,
20th February.
February. That is the only 20th now available.
already.
Yes.
32 urgent, 33. He promotes.
For the respondent, please.
So We don't have time to start the arguments. We
This
just
is,
did
my lord,
the
a
argument.
short question, my lord. The probate is granted by this honorable court, division bench. There are 4 suits are pending, my lord, between the joint family members. All the suits are, my lord, pertaining to the partition only. Some of them claim, my lord, the partition against only ancestral property. Some of them claim, my lord, individual as well as ancestral property. All the 4 suits are pending. My lord, the family members, my lord, one Thima, my lord, Munisham Reddy having 6 children. Brief facts, my lord. This CP is filed, my lord, after dismissal of the RP to reopen the probate granted by this honorable court. There is same property he claimed, my lord, a counterclaim in the suit. How this petition is maintainable, my lord, is the question. When the person, my lord, very same petitioner, counterclaim in respect of very same properties, it is open to him to, my lord, the agitate is grievous, my lord, in respect of those aspects also. The probate granted, my lord, 7 years back. Now, my lord, this cannot be, my lord. They are, my lord, dodging the matter. All the 4 suits are among the members of the family. You.
Chitramaya died issueless. There was no legal heir. They are claiming under the will. When Chitramaya died issueless, all the other legal heirs, brothers and sisters can intervene. When the matter was pending, suppressing the litigations, they obtained a probate before this court.
Adopted children, he has no my lord, issues.
We'll have it on, give a date, please.
20th.
The advocate who represented before the trial court himself drafted a bill and nowhere.
No, don't make allegation against a lawyer.
We are
The
not
lawyer,
holding it
my lord,
today, council. We'll have it on some other day, please. Give a
20th
date.
February.
20th.
34th.
Don't make allegation. Lawyer will do his job. That's all.
Yes, item 34.
34, Veeresh Arbudiyal.
Karnataka Urban Water Supply Drainage Board. What is this matter about?
And
And acquisition.
It was lapsed now. It was
Held lapsed. Held lapsed.
Passing of time.
Not passing. of
Well,
time.
Lord, the final notification was passed after 1 year.
Oh. Declaration date. Give a date even before that.
11th. 11th February.
All they are served, nobody. It was allowed, the repetition was allowed.
It's against the.
Corporation, my lord, is served and under.
35, Murugesh V. Charity.
For the respondent in matter. Say, a matter which could have been disposed of. There was an allotment in my favor.
They raised the demand, my lord. They're already sent, they have to agree to pay that amount, my lord.
There was an allotment in my favor, a G category site. I paid the amount, sale deed was executed, all those things had happened. But ultimately it was found the site was not in existence because of some alteration of the plan, etc. Then I asked for a alternate site. Alternate site was allotted. For alternate site, my value as on the date of allotment was sought. I challenged it in the writ petition, pointing out that valuation is not correct, etc. I succeeded in the writ petition. When the matter had come up before earlier on the occasion, court said, why all this on principle litigation? Why don't you pay the amount? Not that it is something which you cannot afford, was the observation. Then I said, all right, I will pay the amount. I went and offered to pay the amount. They did not accept it. Probably commissioner was not at that time informed that in the writ appeal it had come up. Then I again reported it here. Their advocate informed him. Now, an interest at the rate of 18%.
You hold out a site.
For 60 days, no interest, thereafter 18% interest, then 21% interest is levied. I also said it may not be levied, it's not permitted under the law, therefore it may not be levied. I also said, instead if there is any difficulty, please levy the interest of SBI for housing loan, whatever the interest, please that can be levied.
And also you agreed.
Commissioner says there is no provision made for levying interest, but anyway, in respect of other things, we levy interest, I will be levying interest. And even now, I took a DD and went there. If this demand is issued, I would only say, if my learned friend could point out to them that levying of interest, that too at this rate, I said, you cannot levy, but anyway, I will pay the interest as per the home loan of SBI.
Appellant's Council, you allot a site on 26/7/2007.
Yes, my lord.
Site is not there. You ultimately say on 25/2/2020 that you will allot a
He requested the RMB
an alternate site
my
on, please, on payment of rupees 4,000 for allotment of alternate site. That is all that is sought at that time as excess amount, 4,000 rupees. Then again, on 4/6/2020, you say 21,27,477. He's ready. Now he says he'll pay interest at some reasonable rate. What is this justification for claiming 18% interest?
Generally, MLAs, ex-MLAs, they will not give the money only. At least he is paying the money.
And he's agreeing to pay the money. He's agreeing to pay interest. Grab it, otherwise we'll dismiss this appeal. Otherwise we'll dismiss the appeal. Please take it from us. Yes, Monday.
In orders.
RMB my lord, RMB second stage, my lord.
Is it that court cannot afford to pay? Can I say I will advise him to pay?
Yes, needs to.
Two alva. Two. Let's start. The form number 2. As the petitioner is ready to pay rupees 27,477 along with the
As the demanded.
VDA. It is further submitted that client is also ready to he further submits that reasonable interest also.
Reasonable interest as per SBI.
The SBI rate of interest on
home loan.
Their submission is placed on record. Learned counsel for the appellant shall seek instructions from the Commissioner PDA. Report to the court regard the its stand released on Monday in orders. Monday for admission. Just file a memo saying that let them deposit the person.
But we've taken a DD and went there.
Just off the record, you tell that court wanted to pass order confirming the order of citizenship, so that they may agree. At least this much amount they will say.
The fair approval, my lord. SME, RMB second stage, my lord. That's there.
All these things you have done. No? Allotment RMB they will ಮಾಡಿದ ತಪ್ಪು. And they will pay whatever. We have to go by record.
36, Jaikar Shetty H.
Please, ma'am. This appeal is by tenants, my lord. The property has been granted in favor of the tenants. The
Sir.
fifth respondent, my lord. Next day. Any convenient day,
20th.
20th, please.
Here,
That also. You are for the auction purchaser. Can we have it in the week after that? Because.
Fifth, sixth.
Serial number 24.
6-2.
Second is 40. Notice.
Notice is out.
What's your?
38.
My lords, I appear for respondent, my lords. I seek passover, my lords.
Pass over to next week.
Please, my lord. Any convenient date subject to the.
Oh, okay. Finish the chamber and then. The other one is pronouncement and one more. Only pronouncement. Finish the pronouncement and that is better. Let us take some time. Pronouncement will only. Yes, that is better.
Madam, Madam Court Officer, Madam.
ಹೇಳಿ ಸರ್.
Serial number 38, ಯಾವ date ಕೊಟ್ರಿ ಮೇಡಮ್?
ಯಾವ ಡೇಟ್ 21 ಕೊಡ್ಲಾ?
ಹಾ. 21/2. ಓಕೆ ಸರಿ ಮೇಡಮ್, ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು.
Court officer, sir. Hello, madam. Hello, court officer.
ಹೇಳಿ ಸರ್.
Madam, 39, serial number 39 ಕರೆ ಏನಾಯ್ತು ಮೇಡಮ್? Serial number 39.
21/2 ಶುಕ್ರವಾರನೇ. ಕೊಡ್ಲಾ? 21/2 ಅಂತೆ ಸರ್.
21/2 ಮೇಡಮ್, 39.
20 ಅಂತೆ ಸರ್.
22.
22.
Okay, madam. Thank you. Court officer, madam. Court officer, madam.
Sir, ಹೇಳಿ.
Madam, 38 ಏನಾಯ್ತು madam? Seal number 38, madam.
ಡೇಟ್ ಕೊಟ್ಟ ಇಲ್ಲ ಸರ್. ನಿಮ್ ಜೂನಿಯರ್ ಹೇಳಿಲ್ವಾ ಸರ್?
Okay, okay, ma'am. Okay, ma'am. Okay, thank you, ma'am. Thank you, ma'am.
21st.
21st. Thank you, ma'am. Thank you so much, ma'am.
Hmm.
1, pronouncement of judgment. Still number 1, Sumana Nagana.
Contracts are indeed contracts of service, not process. Therefore, we further held with the contention that they can be sent out without any notice. Cannot be sustained. Other than the facts and circumstances of the case, we are in agreement with the findings of the learned civil judge with the contract being one of service. It can be terminated on allegations of malfeasance or misfeasance only after issuance of wrong notice in that regard. Directions issued by the learned civil judge are therefore upheld. Interim order dated 29/2024, passing appeal number 684/2020 is sustained and made absolute. With regard to the other directions issued by the learned civil judge, they have held that they cannot be construed as a direction to regularize. That cannot be in the facts and circumstances. However, here in the facts and circumstances, we are of the opinion that the appeals can succeed only to the limited extent of stating that the directions issued by the learned civil judge shall not be understood as directing regularization of DVPs and methods in sanctioned posts to which they may not be qualified as per the record. However, we are of the opinion that the state is duty bound to consider the recommendations of the High Level Committee and to frame a proper scheme for fair wages, proper working conditions of DVPs engaged pursuant to its policies. The question whether the contract employees have the eligibility to be continued as against existing posts, since they are admittedly carrying out statutory duties assigned to them, shall also be specifically considered. The needful shall be done within 4 months from date of receipt of copy. The order of the learned civil judge is sustained.
But what about the regularization?
Specific direction to regularize against the post. That cannot be a direction from the post. Because what was held out was only a contract. There was no holding out of a regular employment to the rule. That is our fighting on the facts of the case. We have held that there is no right for regularization. But the state, we have also held that the state having, it is not as if they are usurpers to the post. The state having stated that there is a right to contractual appointment. Even after the decision of the apex court Uma Devi's case, the state of Karnataka, in exercise of its legislative power, have enacted the Karnataka Daily Wage Employees Welfare Act of 2012 to address the grievances of ad hoc employees engaged in public service who had no claims for regularization in terms of the judgment of the act. We find that the learned civil judge has considered all relevant factors, materials to come to the conclusion that the claims of the petitioners are liable to be considered. Even in case all the arguments of the companies of the government are accepted, we feel that the government cannot refuse to work out a scheme for fair wages and conditions of service of a large number of persons admittedly engaged in public policy and carrying out the essential and statutory duties of the electricity transmission companies. Though economic considerations may be relevant and of importance from the point of view of the government, we are of the opinion that even such considerations cannot stand in the way of the government considering a fair scheme with regard to fair wages and proper conditions of service. Then, having considered the contentions advanced and given our anxious consideration to the case law placed before us, we hold that the contract entered into by the S firms with the petitions cannot be characterized as a contract for service and is definitely a contract of service in view of the clear and direct exercised by the appellant on the petitioners. We also notice that the statutory duties being performed by the petitioner would have to be carried out by the appellants. There is no material on record to show that the appellants do not require service.
I just wanted to, I'm not arguing the case. In view of the 20th December 2024, that is my Lord Justice Vikram Nath judgment, where sanction post was a condition precedent in Uma Devi's case, that got modified stating that, yes, Jaggu. Yes. But single judge, single judge said, you frame a scheme, that is a position.
Overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively recognizing it against it. who have rendered indispensable service. If considered that, which is the reason we are coming.
Your lordships left it to the government.
And if there had been a holding out of regular effort, then something, such holding out also, according to us, is not possible against it. That would work against our agencies. Cannot hold down that we will regularize against one post which are probably not there at the time when it is being considered. And disregarding the recruitment rules for those posts. It have to be now clarified further in the appropriate proceedings. It considered all the contentions, all the judgments as much as could be have been.
But they,
We have stated what every judgment says. We take it from us, we consider all.
but 20 years, what they should do it, that's the position.
Yes.
Great.
One matter, my lord, which your lordship, my lord, in this combination had disposed of, against which I filed review, my lord. That's the writ petitioner council has issued an NOC and enabled me to file the review, my lord. Matter is not listed since the office objection is that I have filed the review and not the earlier council. But I have filed it along with the NOC wakalat. They have issued. No, my lord, it's.
What happens in the court is only.
Yes, review is only of the order, my lord, not of the proceedings, so it's not listed.
Yes.
On the next day.
Court officer, madam. 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 Madam.